this video, we're going to apply the law relating to minors from the Contract and Commercial Law Act 2017 with an example. So our example is a typical purchase of a vehicle. So we have a friend here is 17 and we have a dealer with a car. They enter into a contract and the contract is for the 96 Toyota Corolla, say $5,000. Servicing, insurance, payments, 18% finance rate, 3-year terms, and he's going to pay a deposit. So this is all agreeable, so the minor pays a deposit and has his brand new car to drive off in. So he heads off down the road in his motor, feeling pretty good, until he has an accident. Now, where are we with the situation? Now, let's assume he's pretty unhappy because his car, as you can see, is smashed up. So he can't get to work, he can't continue payments, and he's not going to complete the 3-year payment. So what are we going to do? Now, the dealer's option at this point is to go to court, and we're going to end up in front of the judge. And what is the judge going to do? The judge is going to apply the Contracts and Commercial Law Act following from Section 85. Now, as we know, there's two options here. The contract could be fair and reasonable, in which case it could be enforced, or it might not be fair and reasonable. Now let's turn to the legislation itself just to see where we're getting this from. So going back to our diagram, which is on Canvas, you can see the Minors Contracts Act. We have to follow through these procedures. So does the law apply? Is this person a minor? And therefore the Act applies to them. And you'll see down here, that's our first step. So let's turn to the Act itself. Now we're in Section 85 through, which we looked at before, Contract Capacity of Minors. So Section 85, what does this tell us? That a minor is a person who's not yet 18 years of age. So you would simply write down that under Section 85 of the Contract Commercial Law Act 2017, a minor is a person under 18 years, and our subject in this case is under 18, therefore the Act applies. And you need to be that specific. So we know the Act applies to this person. The type of contract is one of these general contracts, simply meaning it's not an employment or insurance of life contract, it's only life insurance. We've decided the person's a minor, it applies. So is the contract enforceable? And we know the answer to that is no, as a prima facie, which means as a starting point. So Section 86. Unenforceable against the minor. So we say pursuant to Section 86, it's unenforceable against the minor. So we're advising the dealer and telling the dealer you cannot enforce this contract against the minor. However, we know that under Section 87, the court may inquire into the fairness and reasonableness of a contract. So we are going to have to look at whether this contract is fair and reasonable. Now at this point, it's best to go through to Section 90 and look at the matters or factors the court must have regard to in deciding if it's fair and reasonable. So the circumstances, subject matter, nature and value of the property, and age and means of the minor, if any. So at this point, we'll go back to our contract and look at those questions. So this is a 96 Toyota, $5,000. We could look at prices at dealerships and look at the average price and see what the market is for a car of that age and mileage. We might find it's only worth $3,000. 3 months servicing is quite excessive, and if that's carried out by the dealer, it's just a way to make more money. Insurance probably looks okay. 36 months is very normal. 18% finance is not particularly high for car finance for a 17-year-old, and that deposit just looks fine. So is this contract fair and reasonable? Well, we can start off by saying probably not fair and reasonable, because if it is, the courts will enforce it. If the contract is, question is whether the contract is not fair and reasonable. So we've looked at this contract and we would simply list the factors. So the price is too high, the servicing is excessive, the minor has low income, which is their circumstances, and let's assume, for example, a dealer pressured the miner with the old line of "it's a good deal if done today." Now, those factors together would suggest that's not a fair contract. So that leads us to the question of what is our judge here going to do? And for that, we'll turn back to the Act. And going back one section, we have court orders where the contract is not fair and reasonable. So our judge may simply cancel the whole contract, or could make an order allowing the miner on the conditions that the court, meaning the judge, thinks fit, just to cancel the contract. In other words, do something to complete it normally. So if we apply that to this circumstance, we could simply list them that the court may cancel the contract and may, for example, say to the miner, well, you owe $4,000 on this, let's say $3,000 to complete. Now written here, you decide, because that's the basis in the assignments and questions. You just need to make a decision having set out the law, which is the factors in section 90, then the practical issue of what's in the facts to tell you how to use those factors, and then what you think the outcome will be from the judge. So at this stage in this case study, we can say that, let's assume the judge is going to cancel this contract and say, nope, wasn't fair, contract's over, that's it. The problem is though, that's not it. All that's happened is this contract here is now gone. So they've cancelled the contract, so they have no contract between the two of them. But our friend the miner still has this smashed up car, the dealer still has the money. What do we do about these things? And that's where our next step comes in, which is compensation and restitution. So if we go back to our notes here, just to highlight once again, so we've gone through these steps and we've decided that the contract is not fair and reasonable. So we've gone through our miner, it's not enforceable. We've gone through the question of is it fair and reasonable. We've applied our factors in section 90, and we've gone down this track to say nope. And we've picked a remedy, which is cancel the contract. But as said, we've still got the miner with a smashed up car and the dealer with only $1,000. What do we do? And so under section 95, the court has this option to deal with these other issues by applying compensation, which is money to either party, and ordering property transferred. So let's just have a quick look. Section 95, here it is, compensation and restitution. And the court, as we've seen before, this relief may be granted to a party, so the dealer or the miner, and it could vest or transfer property to a party. So in our example here, that could simply mean give the car back to the dealer, or leave the car with the miner and get the miner to pay some extra money to the dealer, $3,000 for example, to finish the contract off. Now that would be relatively simple, particularly if the car hadn't been smashed. However, what if we introduce some other factors? Now let's assume, for argument's sake, that the miner was driving along not long before the accident, stopped by our friendly police officer here and given a ticket for driving under the influence, and since he's 17, that's a very low level of alcohol consumption. Following on from that, he has his accident having gone through a stop sign. Will this change the issues for us? Well, the answer to that is almost certainly. So now when the judge is thinking compensation, the change here is that the miner is almost entirely at fault driving drunk, which means there will be no insurance on the car to cover the cost of the damage. So the dealer will lose all the money, the outstanding $4,000. So restoring that vehicle to the dealer is one thing, so it might be worth $200 as a wreck. So we might have restitution, so the car goes back to the dealer, and we might put in here some extra money for the dealer. So let's give the dealer, let's say $4,000 or $3,800 as compensation, and the car goes back to the dealer. So that's the wreck, and that's going to be worth typically something like $200 for a wrecked car, and that would balance the situation out in this circumstance. Now clearly when you think about these situations, for an honest car dealer, this is a bad outcome. the dealer, let's assume the contract was in fact actually fair and reasonable, yet the car was smashed up by the individual and therefore no insurance because they were drunk and went through a stop sign. What could the dealer do about this apart from don't sell the minors? Well, the answer is to have a guarantor. So this is how a guarantee would look like in a diagram sense. We've got our two parties, so the dealer and the minor are the parties to the contract. And here we have Sally, the minor's mother, who is going to be the guarantor or surety for this contract. And you can see here, this is a separate contract. So if this particular contract here is not fair and reasonable and the court cancelled it, then it will have no effect on this contract. Now, the law for this comes from section 102, and it basically simply says every contract of indemnity is enforceable against that person, and it is not affected by any other provision or any other part. In other words, any orders made under this Act, for example, to cancel the contract, will not change the basic rules up here that you can sue the surety or the guarantor. So what that effectively means is we can simply take this contract, get rid of that, get rid of our little friend here, and all you're left with is this. The guarantor or surety, same thing, owing money to the dealer, and we just absolutely ignore the minor's contract and the minor's involvement in this. So regardless of what happens, our friend here, Sally, is going to have to pay that contract, which would mean the outstanding hire purchase agreement for 3 years, 36 months that is, at 18% finance. And since her child, assuming that's her child, has smashed up the car without insurance, it probably means pay it all today. Now, the only other thing the dealer could have done in this example was to have gone to court in advance and had pre-approval of the contract. This is highly unlikely in a hire purchase of car because of the cost of going to court and the time consumed. So most people will go for guarantors. And to finish today, for absolutely no good reason at all, there's some Pumbas wandering around the streets of Victoria Falls, Zimbabwe.